Hello everybody, my name's Piers Strickland and I'm a partner at Waterfront Solicitors LLP in London. I'm the joint head of IP, specialising in IP, and I'm very grateful to be speaking today to the Think Global conference about how to enforce your intellectual property rights, ensuring your contracts are bulletproof. Please have next slide. Thank you very much. So I've attempted to break these tips down into steps. And the first step is to identify your IP. Now, all companies around the world are likely to own some IP, but the nature and value of the IP that each particular company and person will act will differ from person to person, to company to company. There are no unified worldwide IP rights. And this is something that's very important to grasp. IP rights are generally national rights, although there are some exceptions. For example, there are pan-European rights. So if you are a member of the EU, then you may be able to benefit from pan-European rights. There are also some schemes run by the World Intellectual Property Organization, otherwise known as WIPO, and those schemes facilitate international property applications. In other words, there are central international schemes run by WIPO that enable you to put in a central application in at WIPO, and by doing so you have a bundle of national rights. So the idea of those WIPO schemes is to make it easier to obtain a bundle of national IP rights and registrations across the world. Now, although IP rights are essentially, as I've said, national rights, there are general types of IP which are common across the world in terms of broad descriptors of IP rights. Now, the precise details and scope of protection and qualification criteria are, of course, a matter of generally national law. But in terms of the general types of IP law that you find across the world, they are, and some people will be familiar with some or other of these, they are generally copyrights. So copyright protects a range of different works, such as literary works. So that would be books, and literary copyright also protects things like source code in software, computer software. There are artistic copyrights, musical copyrights, film copyrights. So there's a range of copyright works. Moving on to the next common type of IP right, there are trademarks. And within that, there are registered trademarks and sometimes unregistered trademark rights. Patents is an important monopoly right, which gives new and inventive ideas protection, often time limited, and patents are generally a registered right only. And then there is design IP protection as well, which comes often in the form of registered and unregistered rights. In England, where I'm based, we also have the common law right of passing off, which protects goodwill against misrepresentation and damage. In other countries, there are similar laws, often known as laws against unfair competition. Databases are often protected by different types of IP laws, sometimes by copyright. Sometimes there are their own individual laws, such as in the EU, there is the specific database directive, which provides for a EU-wide database right. Lastly, we have the law of confidential information. This is, strictly speaking, not an IP right, but is often treated as one. So once you have identified your IP rights, then you are able to move on to step 2. And next slide, please. So step 2 is locking down your unregistered rights. So at step 1, we went through the different types of IP rights. As you can see, there are, and as I've explained, different types of IP rights, some of which are registered, some of which are unregistered. So the unregistered rights are still very important, particularly as in some situations you're getting these automatically. And here, for example, copyright is an important example. Copyright comes into existence, at least under English law, automatically when a qualifying person does a qualifying bit of work, which then automatically, upon the creation of that qualifying work, automatically brings into existence a copyright which protects that work. And it's time limited in the example of copyright, and there are different durations for the different types of work. So if you have potentially valuable unregistered IP rights, such as copyright, then you need to make sure that your company actually owns these IP rights, because I act for a range of clients in different industries and get involved in disputes where sometimes companies have not locked down these unregistered IP rights to their detriment. So there are different ways that these problems can arise. So, for example, if you have commissioned a third party to create some work for you, to develop something for you, you need to make sure that any unregistered IP rights that subsist in that commissioned work end up being owned by you. And this applies with respect to copyright. So under English law, it may be the case that you engage a third party to come up with some work, and the default position is that that third party may be the owner of that copyright, unless you agree something to the contrary in a contract. So the position under English law is that you will not own that copyright. Copyright will not be transferred from the creator, this third party, to you, the commissioner, unless the creator of the copyright, the first owner, agrees to transfer the copyright to you and signs a document to that effect. And of course, contracts like this can be quite simple. You can just say, on full payment of your fee, you, the copyright creator, agree to transfer the copyright to us, the commissioner, and that copyright, all those IP rights are effectively transferred once full payment has been made. That's quite a common way of doing it. And obviously, as I said before, you need to make sure, at least that this is the English law position, the position may be different elsewhere in the world, that you get the signature from a first owner on a bit of paper or electronically, which agrees to that position, i.e. once you've paid them, they agree that the copyright is owned by you. Otherwise, you may be in an unfortunate situation that you don't get the IP in something you've paid for. And obviously, you want to make sure that in most situations, you do get the IP you need. So when you're dealing with work that your employees have developed, then the position is likely to be more friendly to the employer. Again, looking at this situation under English law, where an employee carries out work in the course of their employment duties, then the underlying legal position and legal protection for the employer would be that the employer would be the first owner of copyright that employee has done in the course of their employment duties for the employer. So you still want to, as a matter of best practice, have a written employment contract in place which has specific intellectual property clauses within that employment contract, which will set out in clear terms that what you want to achieve, such as you may want to make sure that there's express terms in the employment contract, which says that any intellectual property developed by the employee during the course of their employment contract, such IP would be transferred to the employer automatically. And you also have sometimes additional clauses that the employee will assist if they need to have their further assistance in that respect. So that is important, that you have those employment contracts in addition to perhaps the underlying law. And for all of these situations, what you need to make sure is that you have a clear and well-documented set of agreements with your any third parties that you've developed material with or commissioned to do work, and indeed your employees. So if it ever comes to somebody looking at your IP portfolio, you have a suite of documents which you can show to them to say, okay, this is the IP we got from these third-party developers. These are the documents which prove this. With respect to employee-generated IP, these are the suites of employment contracts which prove that. The more documents that you have and are compliant and effective as you go along, and the better you collect and maintain this suite of documents, the more effective you will be able to assert your copyright in the future. And indeed, if you're looking at selling your company, such a effective document management will also help in that respect too. Next slide, please. So after locking down your unregistered IP, the next step is to turn your mind to your potential registered IP rights portfolio. So registered IP rights are often very powerful and valuable rights, but you need to make sure that in some cases you act quickly, because delay can mean that you miss your chance at getting a certain types of IP registered rights at all. For example, patents. If you have disclosed your invention before you make an application, that can be terminal and prevent you getting a valid patent at all. Likewise, for things like registered designs, if you're not quick enough, sometimes if you've had your valuable design on the market for too long, then you can lose your right to obtain registered design rights protection. In other respects, such as trademarks, you'll be in a much weaker position if you have not registered your trademarks and you then are seeking to rely on unregistered trademark protection. It's generally where you are able to obtain registered right protection, it's generally a good idea to do that. And that will help you in your contracts protecting your IP. If you can point to a suite of registered IP rights, then that will place you in a much better position to deal with third parties, including those that you contract with. Now, in terms of trying to increase the value and scope of your registered IP right portfolio, one of the key things to do here is to register your key territories, those territories that are vital to your business territories. Now, as I explained earlier, there's no worldwide single unitary IP rights. No, there's no single worldwide copyright or worldwide in terms of registered right. There's no worldwide patent that you can just get one patent that covers the entire world. And likewise, there are very few companies that have the budget to get registered rights in every single country around the world. So particularly for those companies who are relatively young and with limited budgets, you need to be very precise and targeted about which of the territories around the world are your key ones, those that you wish to set aside and utilize your budget against. So once you have identified the key territories, and then you've identified which IP rights you want to try and get registered protection in, and you've assessed that alongside your budget, then you can make applications accordingly. Now, all of this is quite complex, and this is a process which I think engaging an IP professional is likely to be money well spent. You may say, someone like me, being an IP professional, would say that, but in my experience, it's money well spent, and you can save yourselves a lot of problems in the future, as there are various pitfalls to be made in making IP applications. But you're also likely to get stronger, more robust IP rights, registered IP rights, that is, out of this if you engage a professional at the outset, and this in turn will help you in your contracts and generally protecting your IP thereafter. Next slide, please. So as I come on to the next step, and this is the final step in what I am here to talk about today. Actually, no, I have two steps. There's step 4, and I think I have step 5. Yes, so we're on to step 4 at the moment. Now, in terms of how you want to exploit your IP commercially, there are various choices you need to make. So when you come to commercialize your IP, you are essentially letting third parties use your IP to a greater or less degree. And the choice of which contractual mechanism you use will be important to that choice. Some contractual mechanisms offer more control over your IP, others less so. So I mentioned here, there's various ways of controlling your IPs via contracts. One form, of course, is to license your IP to third parties. And there's various different flavors of license. At the one end, you could hand over all of your IP under various contractual protections. So your licensee gets all of your IP in their possession, and you seek to rely on your contractual protections in the license. That may be more risky. You may need to trust your licensee more in order to enter into such an arrangement. Alternatively, there are more sort of arm's length licenses. So there is increasingly in the software world, software as a service contracts, where the licensee actually gets very little of the licensor's IP apart from the end service. That's obviously attractive from a licensor perspective. Franchise agreements are agreements that actually have an IP license at their core, but this model does allow the licensor, the franchisor, to have a great deal of control over how the franchisee uses the IP in often very controlled ways. Joint ownership is another way in which you could agree to share your IP with somebody else, but it's not as common. And also, for example, under English law, if you were dealing with copyright, one co-owner could not utilize the copyright under such an agreement without the consent of the other joint owner. So it can be quite a cumbersome arrangement. And of course, you may choose to sell your IP or bits of your IP via a contract as well. And the key there is to be very careful about defining what IP is being sold. You don't want to give away too much by accident. And if you're the buyer, you want to make sure you are getting what you need and not too little. And also, if you are a buyer of IP, you also want to consider whether or not you should get some warranties and or indemnities about the IP from the seller you are buying in order to protect you. Now, could I have the next slide, please? So now I'm on to the final slide, and I wanted to just talk about some common pitfalls that I see companies getting involved to when they are licensing and otherwise contracting with respect to their IP. And a general suggested approach here is to think about planning for the worst when you are negotiating your contracts. Indeed, when lawyers draft contracts, they are continually thinking about how to protect their clients if things go wrong. And, you know, at the outset of a collaboration, no one really wants to think like that, but you need to protect yourself under your contracts if things do go wrong. Now, the ways to try and protect yourselves is to potentially to try and negotiate unequal termination rights. So this may mean that you can get out of the contracts just on notice, you know, giving a certain number of days notice, but perhaps the other side can only get out of it if you are in breach. So, you know, in other words, you want to try and get out easier than in an easier situation than the other side, potentially. Also, perhaps you want to make sure that the payment obligations mean that you can terminate the IP license promptly, particularly if you're the licensor. If you're the licensee, perhaps you want the reverse to be true. Also, if you're a licensor, don't give the licensee more than what they need. Remember, exclusive generally excludes the IP owner. So be careful of giving away exclusive rights when you yourself, the IP owner, also wants to exploit that IP in the territory which you're thinking of licensing it to. Think about limiting your contracts to a particular territory and or field of use. Where you're talking about confidential information, be careful not to divulge more than you need to. You know, once you've put your confidential information out there, it's very difficult to police. Lastly, think about your choice of law and jurisdiction clauses, which are commonly found in contracts. You know, ideally you want to have those which are in your favor. So, you know, if in my example, I'd always want English law to be the choice of law, because that's the law which I'm most comfortable with. You need to make sure you get the choice of law into your contracts that suits you. And likewise with jurisdiction, you want to make sure that you have the right to bring any kind of court action in the courts that suit you. And often if you are operating internationally, you may want to have a clause which says you have non-exclusive jurisdiction in respect of your preferred court. So in that situation, I would seek the non-exclusive jurisdiction of the courts of England and Wales would be one of the ones that I would choose. So all of those are common things to think about in ensuring that your contracts are bulletproof and how you can best enforce and protect your intellectual property rights. I hope you found this talk useful, and I'm available, I think, after this recorded talk to answer some questions. Thank you very much.